Hello everyone, and thank you for joining us today for our Chartered Insurance Institute webcast with Flaxman Partners. I'm Catherine Kennett, Policy and Public Affairs Manager at the Chartered Insurance Institute, and I would like to welcome you all to our session on the Infinity Reliance Judgment, a body blow to brokers. On the 28th of November 2023, the High Court handed down its judgment on Infinity Reliance Ltd versus Heath Crawford Ltd. For the insurance industry, and brokers in particular, this is probably the most significant judgment related to broker negligence since a case in 2012. The Infinity case concerns the broker's advice about the scope of business interruption insurance available on the market, and is focused on the need to ensure an adequate level of cover for what turned out to be a growing business. The judgment is required reading for anyone advising clients on general insurance of any type. Flaxmans will lead you through the minefield of information and highlight points for actions. Today with us online, we have Roger Flaxman, Chair and Principal Consultant, and Michael Wilson, Director at Flaxman Partners, who I'm sure a lot of you attending this webinar will already have seen before. There will be time for questions at the end of the presentation, so please feel free to use the question box you can see on your screen, and we'll work through these once the webcast is complete. So without further ado, I'm going to hand over to Flaxmans.
Good morning, everyone, once again. And as Catherine just said, it's myself and Michael doing our usual double act on this rather interesting case. Now, this is a much reported judgment. Virtually every solicitor that does insurance has given a report on this. So many of you may well have read into this already. But we're taking an angle on this, which is not to speak to you as lawyers, because we're not. We're looking at this from the point of view of the insurance industry and its implications for brokers and insurers. It is actually brokers and insurers, it's not just insurers. But I'll explain to you in a moment why we've called it body blow for brokers. InsurTech. InsurTech is in fact removing human contact from much of the insurance industry's customers, with the customers. But the courts are not taking this into account when they're looking at the complaints and claims against insurance practitioners. They are judging the standards of insurance broking in particular by the standards based upon an expected dialogue between insurance practitioners and customers. Now, the word dialogue actually features quite strongly in the judgment. And I haven't got time. It would take at least 2 hours to go through the judgment in any detail and explain all the nuances. But if you haven't read it, then you might want to by the time we've got to the end of this morning. But the fundamental issue here is that a dialogue is a fundamental part of the broking process. And that's one of the obitus that has come out of this judgment. So the judgment of Paul Stanley, KC, he was the judge in this case, it does make for compelling reading. One of the reasons for this, because actually it's extremely well written. And I'm saying that as somebody who's read hundreds of judgments over the years. I've been doing this for 25 years, and you get to read a lot of judgments in that time. And this one just makes easy reading. And so if you're even vaguely interested in knowing what the nuances of this case are, then you will find it not too difficult to understand. I'll just say now, there's a particularly good section in it concerning proximate cause. Sorry, no, I beg your pardon. I'm sorry, I withdraw that. There isn't. That was another case that we were discussing this morning. How silly. Come again. Now, the point about it is that the judgment brings home the typical court's expectations of standards of practice in our industry. And as was said by Catherine in the introduction, the reason we think this is so important as a judgment now is that it follows several other judgments which are quoted and referred to in this one, which started really with the case of Café de Lecq, which was a Jersey case back in 2012. And one of the points that the judge made in that case is said, well, look, if the broker wasn't doing something that the client could do for himself, what was the broker getting paid for? And that has been a recurring theme in other judgments, amongst others. And when you compare what came out of the various judgments over the years, you will find that it's almost the same half dozen things, which I'll refer to later. So the point I'm making about this one, body blow for brokers, it's not just brokers, it's anybody that's selling insurance. But the further away our industry moves from its customers means the less likelihood there's going to be an active dialogue. And this case is all about the absence of that dialogue. Michael, over to you.
Roger, thank you. Well, as usual, we just need to review the learning objectives for this morning. So it's to receive an overview of the variety of business interruption covers available, to understand the importance and dangers of BI underinsurance, to review the need to establish an appropriate indemnity period, to appreciate the scope of the Infinity Judgment on the role of the broker, and to consider how a broker can ensure the BI insurance provided meets its clients' demands and needs. So, because the Infinity Reliance Judgment is all about a BI case, we wanted just to give a very quick overview of BI, but this is not intended to be too detailed. But just to highlight the fact that there's more than one way of insuring BI. And typically there will be three types of cover. One is loss of gross profit. Another is loss of gross revenue. And then you could also have increased cost of working. In fact, for the last one, for a business with a fairly simple operation that would easily be re-established following a claim, in stark contrast to the business involved in the Infinity Judgment. But where it's a simple operation, a broker might advise that a cover that applies simply to the increased cost of working would be sufficient. I don't think we need to dwell on that.
I think the other point, Mike, that will come out of this is that the principles of the declaration-based type of policy are a fundament of this case. And it's not necessarily a type of BI, but it's a variation on the theme, which actually features very strongly in this case. But we'll come to that later.
Yes, in fact, I think I'll touch on this now, actually, because underinsurance is very much a feature of modern insurance, whatever class of business you're looking at. And it applies crucially to the case involved in the Infinity Reliance Judgment. The problem starts with what exactly is meant by gross profit. If you ask a number of different people, they'll give you different answers. Unfortunately, a typical accountant's definition won't do. There's no shortcut, really, other than to read the definition found in the policy wording. Because if gross profit was simply the difference between turnover and costs, this would make no allowance for the standing charges that the business would be liable for while it's being put back on its feet. So having established the correct formula, there is a need to project the figures through to the end of the selected indemnity period, which we'll be coming on to in just a few moments. So the thing to understand is that a gross profit sum insured that is adequate on the renewal date or on day one of the insurance is unlikely to be sufficient for a claim that occurs towards the end of the policy period, especially if the indemnity period exceeds 12 months. So, as with most property insurances, a typical BI policy will contain an average condition. And underinsurance can have catastrophic effects. Some policies will contain an uplift to allow for an increase in business activity and inflation, and usually such uplifts are associated with a declaration policy, under which it's the policy condition that the insured provides a declaration of actual gross profit at the close of the insurance period, to compare to the estimates provided at the outset. Such an arrangement will typically attract an uplift in the region of 133%, along with the removal of the usual average condition. And particularly for a growing business, this can prove a significant benefit. However, there are times when a broker will find it difficult to persuade a client to accept a declaration policy. Bear in mind that whoever's providing the insurance, whether it's a direct insurer or some internet organization or a broker, they're quite often dealing with a policyholder who is reluctant to go into the detail, if only because they feel that going into that detail is going to cost them more money. And sometimes with a declaration policy, you can find that a policyholder who's asked to pay an additional premium at the end of the policy following the declaration, where there has been no claim, they don't really perceive that they're getting value for money, and they don't really understand the additional benefit they're getting. So it is no easy matter persuading a policyholder to consider these additional options. Let's move on from there.
Can I just add something before we go on there? I've done over 250 expert witness cases in the last few years, and a business interruption comes up more often than it ought to. And I have to say that it's very interesting when you witness a cross-examination of insurance people about business interruption, how few of them understand it well enough to be cross-examined. Now, I'm being blunt about this. It is a real problem, because we know, as people who've had to look at things that have gone wrong, over all these years, that the insurance industry is not good sometimes at understanding things it finds difficult. And business interruption is a difficult concept. But I am going to recommend this. Scylla, the loss adjusters body, have got an excellent new edition, 2024 edition, of an explanation of BI and policy wordings, largely written by the redoubtable Damien Glynn of Sedgwick's, who actually had a part in this particular case. And I would just commend everyone that has to sell it to get a copy of that book, read it, and try to understand it, because it's so important for an insurance broker if you're giving advice on this matter, on this subject. And most people that selling commercial insurance are giving advice on it. You've got to understand the nuances of it, because it's really embarrassing to be in a situation where you're asked questions about something that you can't really give strong and definitive answers. So I recommend that. It's Study Group 265, the 2024 edition. And I can't send it to you because I'm not permitted to, but I know it's available very easily. So I'll leave that thought with you. Anyway, go back, Mike.
So, Roger, I think looking at some of the expert cases you've been involved with, where you've been asked to provide an expert report, have you come across this issue of indemnity periods? Because a lot of BI policies are issued with a standard 12-month indemnity period. So that's one problem. And the other problem, of course, is the declaration basis that we've already referred to. So I can understand some policyholders being reluctant to go for a very long indemnity period because, as we've just discussed already, they have to produce a correspondingly bigger sum insured with a correspondingly bigger premium. So there's an automatic resistance to going for a longer indemnity period. But presumably you've seen some cases where the broker in particular has possibly been criticised for not at least discussing the possibility of going for a longer period.
Well, yes, I have. In fact, I mean, the last year I've had 4 cases, all of which the indemnity period was too short and the sum insured was too low. Now, a lot of the knowledge that I obtain is from reading witness statements, and the witness statements are written by the insurers and or the brokers and, of course, by the client. And the thing that comes out time and time again is the client is terrified of premium. They want to keep the premium as low as possible. And they know instinctively that if they have a higher sum insured or a longer period of indemnity, it's likely to put the premium up. And they resist it. And time again, I've had cases where the client has said, well, I didn't understand the importance of having the right indemnity period. And I thought that if I had an indemnity with a sum insured of so-and-so, that's what I get paid out. Now, I think these are disingenuous arguments in many cases because they're after the event. And very often, as I'm thinking of the particular case I did up north last year, where, in my opinion, the finance director was simply disingenuous. He was being roughed up by his directors of his board and told not to spend any more money on insurance because they were having a tough time. And so he did. And so he was disingenuous in the way that he dealt with the matter. Now, the problem is that the broker, and in this case, quite an experienced and senior broker, got to the point as I can lead a horse to water, but can't make him drink. In other words, if this guy doesn't want to listen to my advice, then what do I do? Now, the court's answer was do it again. In other words, make it so clear to your client in writing that he can't possibly come here and say, I misunderstood. That's what the court is expecting. Now, that's very hard to do in practice. From the insurer point of view, courts will often say, well, why didn't the insurer provide more information that the insured could look at independently if they wished to satisfy themselves that they did understand the terms of the policy. That wasn't, after all, being offered by the broker, being offered by the insurer. But there's a dearth of information or dearth of easily accessible information. I happen to know there's quite a lot of information on the internet, and quite some insurers are really quite good at putting it out there. But brokers don't refer to it, and clients don't know it's there. That's a gap that needs to be closed. And going back to what I was saying at the beginning, if in InsurTech we're going to get further and further away from seeing the customer, we've got to find a way of bridging that gap, because otherwise, when things go wrong, and they will continue to go wrong, the courts will say, well, insurance industry's had its money, let it pay, and fine for the insured. So I think that the bottom line is this. I think it was only a few years ago, and I'm not an expert in BI, I don't profess to be, but it was only a few years ago that I was faced with a problem with a client who was desperate to get a longer period of insurance and they couldn't get it. Probably about 8, 9, 10 years ago. It wasn't available. And I think things have changed a lot now, because most people that I talk to say that when they talk to a client about business interruption, they would start by saying, well, it can't be less than 2 years. And what we know in what we all must accept is pretty much a broken Britain at the moment. Nothing happens very fast. And the chances of getting a business that's collapsed back on track within 2 years is somewhere between bob hope and no hope. I mean, it really does take a long time, because there are so many barriers and inconveniences that we have to overcome. So you could argue, and this is not a facetious thing to say, you could argue that recommending anything less than a 24-month policy, except in exceptional circumstances, is probably the benchmark we should be doing. 36 months is not stupid, because particularly with large businesses, very often, as the modern language goes, the nuances of a business and its dependencies nowadays, particularly with outsourcing of so many services, it makes it much more difficult for people to say, yes, if something stopped tomorrow, I could carry on. Now, in the case that I was talking about up north, which was a food factory, they were absolutely adamant that if something happened to their main factory, they could relocate within 6 months and be up and going. Well, they didn't in 3 years, because life isn't like that. But why did they say it? Did they believe it? Did anybody investigate it? No. It was just taken, oh, all right then. But it didn't work. And that's why it resulted in a multi-million-pound claim.
Roger,
So
if
we've
I
got
can
to
just
think
come in
very
here because
carefully
I'm
about
very
what
keen.
we're saying about these. Sorry, Mike, I didn't hear you.
Yeah.
Say that again.
No, I'm very keen that we allow
Move
time
on.
to look at the detail
Yes,
of
but
the
this is a fundamental
Infinity
point.
judgment. But
Okay.
just to say that I think the industry has come already to the point of feeling that 12 months is not likely to be enough. And
Yep.
really, from your experience, you're really pushing it on even further to question whether 24 months is going to be enough.
Well, on bigger cases, I think you've got to think
I
about it.
I feel as an industry, we need to recognise the resistance that is likely to be met
Yes,
on the part of the policyholder. And
agreed.
I think for another day, that's another challenge, maybe for others to take up, as to
How
how
do you overcome
the
it?
dangers of a short indemnity period can actually be illustrated in a way that the policyholder can understand. We won't discuss any further the declaration basis at the moment, because that's going to come up in our review of the
Well, let me just
judgment.
say, Mike, again, in my experience with this, the declaration basis comes up very, very rarely, but when it does, it's normally because it's been resisted on the basis of having to pay an additional premium.
Well, again, without dwelling too much on the declaration basis, I've spoken to some brokers who have never offered a declaration basis.
Yes, I know. Yeah.
They've never done it.
Yeah.
Now, that might be a reflection of the type of client that they have. I don't know, but
Well, I think after this case, they've got to think again.
I'm not aware of a declaration basis being a topic for discussion generally, and
No,
I think this case will bring that to the fore again. So, on the slide here, the overview of the Infinity Judgment, there were 4 basic headings. One was the broker's guidance notes. One related to the generic example in those guidance notes versus the reality of the insured's situation. Then it brings in the declaration basis. And then also it addresses the broker's need to have a full understanding of the insured's actual method of operation, which in the case of this judgment was not normal. There was something slightly unusual about the way that their business operated. Now, Roger, you've looked into this case in some detail. I'm just wondering if you could give us your own overview as to why this is such an important judgment.
Yes. In fact, we have prepared really quite a long, quite a detailed special report on this. It's much too long to give today, but we'll come back to that later. But what we've had to do is to condense in this thing what really matters in this report. And I've written down for myself at the beginning, what's the benefit of knowing the implications of the judgment? And I think there are 3. The first one is appreciating the common factors present in modern insurance practice that typically give rise to expensive, embarrassing, and time-consuming disputes and litigation. You need to know that. Understanding the rationale behind the decision from an easily accessible judgment which is relevant to the industry. In other words, the benefit of understanding the judgment here is seeing why the judge came to his conclusion, which is very clearly set out in his judgment. And also recognizing the potential elephant traps built into the modern insurtech processes, which can too easily fly in the face of the court's expectations of the obligations of our industry, not just brokers, of our industry, towards its customers. And the courts do take some cognizance of what the FSA's objectives are. They're not entirely separate, although it's a separate aspect of law, of course. But they're the three reasons for doing it. Now, when it comes to the fundaments of the case, the broker's guidance notes, this is a point where the broker in this case, I think, did a rather good job in having available a little booklet, leaflet, which said this is how you assess a business interruption sum insured. And it was a useful thing to do, it was a sensible thing to do, but he made one big mistake. And that was the policy that they sold, which was from Aviva, didn't fit that guidance book. In other words, the guidance didn't have any relevance to the basis of the insurance policy actually sold. Now, somebody described that to me as a schoolboy error. And it probably is. If you're going to have a generic guidance on anything, you've got to make sure that it applies to everything it can reasonably apply to. And that's increasingly difficult to do. But that's what that point is. And the judge really landed on that very heavily. The generic examples of things, now in this judgment, in this matter, the client, who was, I think, a Harvard-educated, eventually FD, he was no fool, and the judge made that point as well. He read this generic booklet, and in it said, amongst other things, for example, you may want to increase your business interruption calculation by 10% to take account for inflation or increases or whatever. So this chap increased it by 10%. Well, that was completely irrelevant to his own circumstances. So he slavishly followed the guidebook. Why did he do it? The judge implied that he was careless, if not reckless. But it might have been, well, if I do 10%, then I can go back to the broker and say, why did you say 10%? You see, because it's a premium-laden thing. Well, if I do more than 10%, it's going to cost me more. And these are all the things that you see in the nuances when you hear these things tested. But that's really the point. The generic example in something, which is a very good thing to do, you've got to test it against the reality. Now, the declaration basis formed a very large part of this trial because they'd had a declaration basis policy before. And it's interesting to read into this. There were more than one person in the insured who had some responsibility for negotiating the renewal at this particular time. And one of those people was, I think, probably junior to the other and took the view, well, I've been told not to do this, and so we're not going to do it. I don't, under any circumstances, want a declaration basis because I don't want to pay any more premium after the end of the policy year. Now, you can understand people saying that, particularly if they don't get the reason for it. And to them, insurance is it's a necessary evil. We've got to pay the money. How quickly can I get this off my desk? We've all been there. You know, I was there for 33 years, so I know what it's like. But the fact is, they got it wrong. And the judge landed very heavily on that. Now, one of the points that came out of this was a word I mentioned earlier, which was dialogue. And one of the experts in this case is somebody known to probably 50% of the people listening to us this morning, a chap called Tom McGrath, who he and I grew up together more or less in the Bowring Empire and Marsh. And Tom is a resident in Northern Ireland, got an enormous amount of experience in expert witnessing as well. And he happened to be on this case, so we've had a little chat about it, along with another chap some of you may know also ex-Bowring, like Sean Finnegan. So we've had some fairly good first-hand feedback of what really went on in this matter. And one of the things that that Tom made the point in his witness statement, expert statement, which the judge picked up on, is that you can't expect two parties to know anything about anything unless they have a dialogue. Now, this is not the first time that the word dialogue has been used. And as I've said earlier, the cases that followed, the various cases that followed the Jersey case back in 2012, which I can quote later if you like, they all really come down to the same thing, that there's a reluctance very often to have a proper dialogue between the insurer and the insured, and or the broker and the insured. And that leads to another thing, which is the insured's method of operation. Because in this case, one of the things that occurred was that the warehouse that caused the loss to the insured was owned by a subcontractor. It burned down, but it was a warehouse which had some particular equipment in it, which kind of did a picking service. What this company did, they made, amongst other things, soft toys and things that you could then have personally labeled with embroidery or whatever. And all that process was surrounded by the facilities in this factory. Now, it was proved in the case that the broker did know about this, but didn't take any account of it. And the insured didn't really make a feature of it. Nobody really thought, what is the implication of a big warehouse with specialized equipment just for us not being available tomorrow and for however long? Nobody thought about it. And in that context, the judge was critical and going to another part of our services, which is the demands and needs. Because we all give a demands and needs statement. But you know, one of the first things that will happen in a litigation is the lawyers will say, where's the evidence that you did an assessment of your advice? Now, ICOBS is not very clear about this. It's not very clear at all. We've had this discussion many, many, many times. ICOBS doesn't really make it clear. It does say you have to give the statement, but it doesn't have to say how you arrived at it. But think of the logic of it. If you're saying to somebody that this policy meets your needs, it's just the same as going to a chemist and saying this medicine meets your needs. If it doesn't, what are you going to say? And so the first thing that people will do is say, where can I see your workings? How did you arrive at it? Now, I wasn't the expert in this case, so I don't know what was adduced, that our experts will. But the chances are that there was no evidence of a demands and needs going into the insured's method of operation. And that comes up time and time and time and time again in the cases that we see. Does that help, Mike?
That's been very helpful, Roger. I think just a couple of comments from me. The business at the centre of this judgment happened to be a growing business because it was the sort of business that grew during the COVID lockdowns.
Yes.
So the expansion in the business was quite dramatic.
Yes.
Now, and of course, the judge was critical of the broker, but was also critical of the insured.
Yes.
And because of one or two criticisms, the judge attributed, I think it was 20% contributing negligence to the claimant, to the insured. But it still left the broker with a claim, something in excess of £2 million.
Yes. Well, can I just read out what the judge said?
Yes, please.
Say that again.
Yes, please do. Yes.
Yeah. Yes, it'll be helpful to know this. I'm just going to read this out because I don't want to mislead you on this. The judgment concluded that the broker was negligent, but so too was the insured, the claimant. The conclusion in the judgment sums it up as this, and I'm now quoting from the judgment. For the reasons set out above, the broker acted in breach of duty by A, providing a misleading and incorrect explanation for how to calculate gross profit, that was the guidance note, failing to recommend declaration-linked cover, he did, but not hard enough. C, failing to explore what additional coverage Infinity might need to meet its costs if the warehouse became unusable. Those breaches of duty resulted in Infinity being underinsured, so that average was applied to its BI claim. As matters transpired, they probably had no further consequence. Infinity contributed to its loss by carelessly, and I've mentioned that earlier, if you remember, failing to apply even the flawed guidance in the booklet correctly. And it is just and equitable that its damages should be reduced by 20% for that contributory negligence, and in the result, Infinity is entitled to damages of £2,336,000, 842. Right. So what the judge's summary makes clear is a major part, and this is another quote I'm making here, a major part of the broker's role is to bridge a gap between the client's knowledge and its own. The ideal client deeply understands its business, its appetite for risk, its capacity to bear loss, and its budget for insurance. The ideal broker deeply understands the cover available in the market, its terms and cost, and how to obtain it. The broker must learn enough about the client's needs and business to make sensible recommendations. It must tell the client enough about insurance to enable an informed decision, not necessarily one the broker agrees with, and an effective purchase. What is required to do that with reasonable care will vary. A multinational corporation with a multi-billion-dollar turnover and a dedicated risk management department needs different treatment than an individual buying cover for a startup business. And bridging the gap does not mean eliminating the gap. It means the client will always know more than the broker about the business. And he says, Mr. McGrath described what was needed as a dialogue, which is a fitting description. So the point is, we all, I think, have considerable sympathy with the broker in this case. And as I'm saying, Mike and I have seen over the last few years countless cases where the broker has given up on really making the client understand for fear of losing the business or upsetting the client. It's perfectly understandable. But the courts don't care. The courts say you don't do the job properly, we're going to find you liable. And £2 million, not a monstrous claim, but it's pretty big. Yeah, nobody wants to have that on the record. So I'm conscious of time, Mike, but I would like to do one thing. Go on.
I would just like to make a comment about the broker's position.
Go on, yeah.
I've got a lot of sympathy for the broker, and bearing in mind that this was a growing business, and the insured must have known it was a growing business, where was the continuing duty on the insured himself to look after his own business affairs? Because sometimes you get the impression that the policyholder is not even expected to think. And if he knew he had a growing business, and recognizing that maybe he should have had a declaration basis policy, but he didn't, he had a traditional sum insured, what was to stop him recognizing his business was growing and contacting his broker to suggest an increase in his sum insured mid-term, just like he would do on his contents policy if he bought some new machinery? I can't see from the judgment that
well,
so why was I just feel that the broker was left with carrying the baby in circumstances where I think the insured could have done more to look after himself.
Well, that's why I think it's a body blow to brokers. I mean, I tend to agree with you. And I think the point is, and I don't know because I wasn't in the trial, but I I haven't read anywhere that the question of the broker, of the client looking after his own affairs during the period, I don't think that it was a feature. But the point is, it's a natural thing to consider. But bearing in mind, looking at it from the other point of view, most clients, and particularly the clients that don't really want to buy insurance, and there's a lot more of those than those that do, will say, oh, well, I've taken advice from the broker, and if I get it wrong, it's that down to him. And a lot of people think like that. So some people would say, well, I'm not going to increase my sum insured because the broker told me what I have is enough. But there's others, of course, that will say, well, I didn't really understand it and I didn't really care because I didn't expect to have a loss. I mean, there are thousands of reasons. But I think you're right. And I think that had it been raised, I think that the judge would have probably taken that view, because that's in sympathy, if you like, the fact that he thought that he didn't use his nous. He was a bit careless in the calculation of his own sum insured by using the guidance book, which was described as flawed. I tend to agree with you, Mike. Can I just move on? When you talk about the broker's best defence, there are things that I've taken out of this particular case that I just want to recite. The overarching feature of most complaints in litigation by a country mile is the absence of records and meeting notes. And believe me, if you go into a situation for any kind of dispute, whether it goes to court or not, if you haven't got evidence to support what you say, it's not evidence. It really isn't. Because the first thing somebody will say is, oh, this was 6 years ago, this was going on, Miss So-and-so. You recall that, do you? Oh, yes, quite clearly. And what did you have for lunch that day? That's the end. That's the end. You can't recall things properly, however good you are. I happen to remember a case that I was involved in back in 2001, I think it was. And I remember a particular conversation with a client on a Thursday night when I was going to the theatre, and it was 7 o'clock and I had 15 minutes before I had to leave. And one of my biggest clients phoned up and asked me a very difficult question. And I gave him an answer and I wrote it down. Thank God I did. Because 9 years later, it went to court. And I had to give evidence as to what I'd said and why. And thank God I had a note. It was only a pencil note on one piece of paper. It was about 40 words, I think. And my advice was to do this. And thank goodness I did it. Because if I hadn't, I'd have been toast. So I'm saying that record keeping. Now, record keeping on computers is more difficult, because if computers give you a limited scope to write them down, the courts don't think like this. Let me just say this. The people that run the courts are the judges and the barristers and the solicitors. They are trained from the first day they start the job to take copious notes on everything all the time. They can't understand why we don't do the same thing. They just don't get it, but we don't. And that's because we're not a profession, we're a trade still. If we wanted to be a profession, we'd have to use professional standards. Having worked many of my years in professional negligence, professional indemnity, and things like that, I can tell you without any fear of contradiction that the majority of professional people, like accountants, chartered surveyors, and architects, are far more meticulous in writing notes than we are in the insurance industry, because we're selling a commodity and they're not. They're selling advice. And that's the difference. So now the next thing that comes up in virtually 50-60% of cases is underinsurance. Now, I'm not going to wax lyrical on that at the moment, but underinsurance is a massive problem. I wrote a booklet for BIBA back about 2013, I think, 14, about underinsurance, which is sometimes is even quoted in other people's witness statement, because it gives a good guidance of the fact that whilst the insurance industry is not there to tell the client what they should insure for, they are there to tell them how they should arrive at the decision to come to a level of sum insured. That is our responsibility.
Okay. Can I just come in there?
Yeah.
I have a feeling we've got a lot of Q&As to deal with. So can I just flag up the fact that there is a fact sheet available related to this webinar.
Yes.
Included in this is an expanded section on the broker's best defence, and we've come up with one or two recommendations there, one of which is possibly slightly controversial, but have a look at that. And then subsequent to this webinar, Roger's very detailed analysis of the judgment will be available, but you'll need to email in for that, or possibly put it on your feedback form, and we'll make sure you get a copy of that. But I think for now we need to come back to our presenter for a look at what Q&As have come up. Because
before we do it, can I just finish off on two other points, because I want I want these recorded in this webinar. The other three issues that come up time and time again, and are in this case, are failing to ascertain the real demands and needs of the client. The use of disclaimers, they are being discredited widely by courts. In other words, oh, you tuck a disclaimer away somewhere and say, well, the insured is responsible to read it. The courts don't buy that, not anymore. And standard documentation, standardized documentation is routinely used in the view of the legal profession to alleviate the insurance industry from responsibility to its client. And that's a point that was made in the case as well, that the judge is more or less saying, well, why is it the insurance industry wants to transfer the risk of getting it wrong onto its client? And that's a horrible thing to have to say. But that's where we are. These are the things that really matter. And all of this is set out in our longer report, which I'm very happy to send to anybody that wants it, because I think it's really, really important as a result of this case to recognize that the signs that were first posted in 2012 with Café de Lecq and have followed in other judgments, it's not going away. This is going to get deeper as we get further and further away from the client and we reduce our reliance on dialogue. So that's all I have to say for now. So Mike, over to Catherine for some questions.
So there are, as we would expect, always a lot of questions. I'm going to just go back to when you was talking about policies, and there were a few, so I'm just going to sort of do them together.
Yes.
But one was, could insurers do better by requesting a 36-month period as a minimum and having a declaration linked? And somebody else said, do you think there is a duty on insurers to offer 24 months as standard rather than 12 months? I do appreciate that it is the broker's job to point this out, but insurers are getting dragged into these cases too, which increases the cost of the claim as well.
I think that this is a very tricky thing to answer. First of all, the word duty doesn't apply to an insurer, but an obligation, possibly a commercial obligation, is more the case. And let's look at it like this. The majority of insurers will say, we're in the business of providing protection to people when they're in trouble. We'll take the risk as long as they're honest with us. And I think that we've got to look at it on the basis that if, as an industry, we generally agree that things are taking longer to recover than they used to, for whatever reason, to offer a policy which, if you were asked after the event, did you think that was enough? No, not really. He needed more than that. Well, why didn't you offer it to him? Because that's the kind of conversation that goes on. Well, he didn't ask for it. Well, how would he know that he needed it? You know from thousands of insurances that you issue every year, or millions, whatever it might be, what these standards are. Surely you should be offering something that is fundamentally likely to be fit for purpose. So to answer the question, if you turned round the sale of BI and you started with saying, well, look, we're not going to offer anything less than 24 months unless you convince us a reason for doing it. First of all, it will increase the premium level. That can't be a bad thing. And B, it will give more time to manage the claim, which can't be a bad thing, because it is all about claims. So I think that the sentiments expressed in those questions are very sound. But I don't think that the insurance industry has a duty, but I think it has a commercial obligation to offer something that is more likely than not to result in a satisfactory indemnity and claim. That's the way I'd look at it.
Thank you very much. And we've got a really good one about cyber insurance, as it tends to come up nowadays.
Yeah.
Will this judgment be applicable to cyber insurance as well as material damage? Typically, this requires two separate policies to cover both claim causes at present, as general insurance policies will exclude claims arising from a cyber event.
Yes, and I think that's an extremely good question. And the answer is the courts will not distinguish between one kind of insurance and another. They look at insurance as an indemnity principle, and they will just work at it from there. I think that this is a massive problem that we're going to see coming out in the next few years. I've only seen a couple of cyber claims in the last year or so. They're not flourishing yet, but they will. Just a matter of interest, I'm old enough to know when D&O started, and that took about 5 years before, well, no more than that, 5-7 years, I think, before they really started flooding through, and now they're ubiquitous. But I think that's a really good point, and the answer is don't try and believe that the responsibilities on us as an industry are going to be different for cyber just because it's not property. I think they're going to apply the same principles as far as they can.
Can I just add something there that once or twice in this webinar, Roger, you referred to up north. So speaking to somebody who's up north in Manchester,
yeah,
I was at a Manchester CII event last week, and we were talking about cyber insurance. And the thing that hit me, there were two things. First of all, to look at cyber hand in glove with directors and officers cover, because it might be that in the final analysis, the directors and the officers of the insured entity might not have handled things as well as they might, and they might not have even have taken out as much cyber insurance as they should have done. And so
if there is
therefore,
enough available.
to advise on cyber in isolation to D&O is not advisable. And the other thing that had never occurred to me, which I thought was a very interesting observation that somebody made, they said that they would never issue a cyber policy document to their client by email.
Really?
In case it was their email system that was unsafe. And is there a possibility that criminals will be watching for evidence of cyber insurance to know that it would be worth their while to launch an attack?
I hadn't thought of that. Good point. Yeah.
That's another issue worth thinking about.
Yeah, good one. Yeah.
That is a very, very good point, very interesting, and I'm sure that we'll come back to cyber again and again in the future. We've had another question, a bit more around helping and supporting. So how does the panel feel an insurer could support brokers and policyholders?
How it can support them? I think by bridging the gap between the policyholder understanding of insurance and the insurer's understanding. I mean, I could write a book about this because I've got some very strong views about this. One of the principles of insurance is good faith. We might not be subjected to the doctrine of utmost good faith in the way we used to, but fundamentally, if an insurance policy isn't based upon the principles of good faith, in other words, I intend to pay your claim unless I have very good reason not to. If it isn't on that, then it fails. And I think a lot of people see that. And anything the insurers can do to convey not the message, oh, we partner with our clients, because you don't. You're not a partner. You never will be a partner. Can't be a partner. And if you were, you'd be in a conflict. So it can't be a partnering. The point is, we want to support our customers, our clients, to the extent that they can trust us. The problem that we have, and this is answering the question slightly obliquely, is that because so much of the claim process is outsourced to people who have a financial incentive in saving their client, i.e. the insurer, money, some of the principles of the original undertaking of good faith are just not present. And very often, in fact, I was doing one of these yesterday, the efforts of the lawyer and the loss adjuster are to set a competition that the customer must overcome. You've got to give me the right answer in the right order, otherwise we're not going to pay your claim. Mike and I have been dealing with some subsidence claims, for example, in the last few months. Dreadful relationship between the insured and the insurer. And in one case, the insured, she's 94, she's going to die before her house has been underpinned. I find that really difficult. But the insurer says, oh, well, we don't have an obligation to do anything different. That's because she's 94. It's not a question of obligation, is it? So I think what can the industry do? It can take note of the fact that we're in a situation in what I call cyberland, where we've got infinite opportunity to convey good messages and good information over the internet and make it available to people without opening the floodgates to claims or fraud. You know, that's not a good enough excuse. Do what you can to re-engage with the customer, to make them feel that actually you quite like them and you do trust them. Unless they do something very, very naughty, including another favourite of ours, when somebody says, oh, I'm not going to pay this claim because it's late notification or something like that. Where there's been no prejudice, don't take the point. Why do you need to? And because it's a legal point, oh, well, we can. And these are the things that come up time and time again in the work that we do. These are the complaints that are made time and time again. Why is the insurer doing that? You know, we haven't done anything wrong. No, but they can. So it's closing that gap of confidence and trust. That's, as you know, we've spent a lot of time trying to influence that for and on behalf of the industry. We do where we can. But insurers' help would be well received.
Have we got time for one more question?
Yeah, I have.
Okay,
Sure.
so the average applies to BI sum insured, but is
Yes.
it also applied to the indemnity period?
I think the answer to that is no, because it applies to no. We haven't got time to explain why, but no. Doesn't need to.
Now, there's a lot of chat and questions about the report and the fact sheet, and asking where that is available or if it can be sent to some of the
if
parties.
you put it in, if you do a response to this webinar, in other words, answer the question. I don't know how it's done because I don't see that bit. But Catherine, how at the end do they have an opportunity to say something?
I think we could possibly, if it's not available on a link that we can, if people want to send their email addresses.
At the moment, we want to gauge the appetite for people's interest before we publish things. The other thing that we are considering doing, just so everybody knows, is that I have considered working with Tom McGrath, who I mentioned earlier, and Sean, to actually run a live event in London for a question and answer. But it will be a fee chargeable event. It won't be a free one because no one's going to sponsor it. But if there was enough interest, we would do it. I think so much can be learned from this case, which is why we spent so much time on it. And I'm saying that from a position of 25 years of giving expert evidence. This is important. And we can really infuse our insure tech advancement with some safety nets if we take into account some of the things that are coming out here and then the other 5 cases that are referred to in our report. So I think that's probably the best way to leave it. If you want a copy of the thing, just put it in your feedback and and we'll get it to you one way or another. All right.
Thank you very much. Safety nets with InsurTech seem to be quite a good idea going forward, but I'm sure that we'll have many more discussions on this. I think it's now time to say thank you very much to you both for delivering the webcast today and for all the information shared. The session will now be available on demand, and please feel free to share this webcast with anyone you think would benefit from it. Keep an eye out, as Flaxman Partners have a series of webinars running throughout the year for you to benefit from, so you will see Roger and Michael again soon. As we said, if there's anybody that has a burning question that needs to be answered, you can also email, and I think the contact details are available on the screen. But thank you to all the delegates for joining us today, and we hope you have a good week. Goodbye.
Bye-bye.